And may it please the court, Your Honor, my name is Jimmy Cannella. I represent the defendant. We're here on the motion to enforce settlement demand. This case stems from a motor vehicle accident that occurred December 7th, 2022. The plaintiff alleged injuries, hired Morgan & Morgan to represent her. They sent the demand over on March 20th, 2023. And I then sent an acceptance to that demand on April 10th, 2023, which is marked as Exhibit B, and I have it up on the screen, Your Honor. Also, Exhibit B to defendant's motion to enforce the settlement. It was to Evan Rosenberg and just said, hey, received this demand. They would like to accept. I have attached the affidavit that there is no other coverage. Also request the check should be there soon. So I accepted and also provided them with the affidavit of no other coverage. Then sent over the check April 18th within 10 days, 2023. Then about 1 to 2 months after I send over the check, I normally start to give plaintiff's counsel a call or email and just to check on the release, which I did in this situation. And I think I included one in here, which was an email in June 2023 that essentially says, yeah, it's Exhibit D, that essentially says, hey, could you send me the copy of the release? And so I usually follow up by phone, by email with plaintiff's counsel just to check on the signed release. This one I called also. They said, yep, everything's fine, no problems. We're settled, just waiting for a plaintiff to come in and sign the release. I said, that's fine, that's all right. So it just kept on kind of moving along. 6 months later, after sending the check, then that's when I get a letter of representation from a new attorney. And this is Exhibit E in my motion. And so I get a letter of rep from another attorney. And so I email both attorneys, the new attorney and the Morgan & Morgan attorney, saying, hey, I just got this letter of rep. We accepted this. Where's the release? And Morgan & Morgan then emailed me October 6, 2023, saying, we don't represent her, client decision. So essentially the plaintiff fired Morgan & Morgan for whatever reason, but fired them after we had sent them the check and everything. And then she just fired them at that point in time. Called them that day and said, what is going on? You told me it was settled. There's no issue. And he said, oh yeah, it was settled. But when she realized there was only a certain amount of money, she wanted more money. And so she fired us. And so then another demand came, the lawsuit came, and I essentially went back to Morgan & Morgan and I said, you told me during this time that the case was settled. And then you told me, hey, yeah, you got a letter of rep that she fired us because it was settled, but she wanted more money. So I said, okay, well then put that in writing, what our discussions were during the settlement. And that's when they sent me the email, which is Exhibit F, and says, hey, James, yep, 25 was all there was. We settled at that. Angela didn't accept that there was all there was to go for. And then that was the reason for firing. So I wanted him to reiterate what we had discussed over the phone during the settlement, that the settlement was good, but that she wanted more money. And that was the reason she fired them, the client decision that she fired them at that time. After suits filed, then I go ahead and file the motion to enforce settlement. And actually at that time, plaintiff's counsel, I mentioned to them that, hey, you understand that this was settled already with Morgan & Morgan. They did not know that. So I had emailed them all the documents showing them settling, didn't hear from them. So that's when I filed the motion to enforce the settlement. The motion and the motion basically is filed saying that the settlement there. Then we get a response from plaintiff's counsel, and the response really doesn't have a reason why, but the brief does contain a reason saying that the affidavit wasn't worded the way they thought it should be worded, is essentially they're saying why they're saying that this should be rejected. They have no, they raise no issues with the demand itself, with the acceptance of the demand, with the delays when the check is received, when the affidavit's received. They have no issues and don't raise any issues with regard to the apparent authority of Morgan & Morgan to settle on behalf of the plaintiff. So there's no other issues with this demand or the settlement, other than they say that the affidavit saying that, is there any other coverage, should be worded differently, is essentially what their argument is. The law in this issue is pretty straightforward from my research, and I think both plaintiff and defense counsel have similar law cases in their briefs that regurgitate kind of the same law that is out there, essentially that there must be a meeting of the minds. That's the Bildball case. That an offer must be accepted unequivocally without any conditions, the Torres case, and that the law favors compromise when there is an agreement to settle. That's the Bildball case again. Again, there are no issues, so I'm not going to go into more detail with regard to the settlement other than the affidavit that is brought up by plaintiff's counsel. The demand itself is attached as Exhibit A to my brief, and if you go to page 4 of Exhibit A, on page 4 it has one of the terms is number 7, and it says, pursuant to the statute, in order to settle this claim, State Farm must provide Angela Lewis a statement under oath regarding whether all liability and casualty insurance issued by State Farm once, and I think the once is out of place there, but State Farm that provides coverage or may provide coverage for the claim issued has been disclosed to Angela Lewis. And so that's the paragraph that is in question. Then so essentially they're saying, give us an affidavit, let us know whether all liability and insurance coverage has been disclosed to us. And so the affidavit that is provided is Exhibit B, under Exhibit B. And it says, from Lynette Hudson with State Farm, and paragraph 2 says, on the date of the accident, the only insurance policy applicable to the defendant and the vehicle he was driving into the plaintiff was policy number such and such, and then limits $25,000. Paragraph 3, I do not know of any other policy of insurance at the time of this accident that could provide coverage for any injuries to Angela Lewis. So the purpose of, as your Honor knows, the purpose of this requirement of the affidavit in the statute is to disclose all insurance, make sure that all insurance is provided to the plaintiff's attorney so they know what they can go after, make sure what insurance is out there. And with this affidavit, that is exactly what has been provided. We provide them, this is the policy that is in question, this is the policy that applies, and there is no other insurance policy that pertains to this accident or this case or the plaintiff. And so the purpose is to find out insurance, and then so we tell them exactly what insurance is applicable and that there's no other insurance out there. The demand itself, again, doesn't specify or say that we have to use any specific wording with regard to our affidavit. It doesn't say that we have to set forth any terms, specific terms in the affidavit. All it says is that we need to say whether all liability insurance has been disclosed to the plaintiff. Simply enough, just tell us what insurance is out there and what insurance applies. And so there are no strict rules or specifications or guidelines that are provided in the demand other than just let us know what other insurance applies to this case. And Your Honor, that's what we provided with the affidavit. We told them what policy it was, and we said that there's none other that applies other than that policy itself. And further, that's why the email is important to memorialize our conversations during the settlement with Morgan & Morgan, that they told me a number of times over the phone, the settlement's good, we're fine, just waiting for the plaintiff to come in. That, you know, and then when we do get the letter of rep, yep, the settlement was fine. She just was not happy with the money. And that's exactly what we discussed during the time of this settlement with Morgan and Morgan.
All right,
I'm sorry. I'm sorry.
no problem. Ms. Hassan?
Oh, I'm sorry, Your Honor. I had just a little bit
Oh,
more.
go ahead.
I'm just 2 more minutes, Your Honor. I'm sorry. And the cases that are cited in both briefs, really, there's really no cases that touch on an affidavit in particular. They go into other things, and then even the cases by the plaintiff, the Grange case, which is basically all deal with a condition, a new condition by the defendant, which basically means the settlement is no good. Like the Grange case where the check was late, the Torres case where the defendant asked the plaintiff to satisfy all liens in the acceptance letter, and then the Cone case where they had a disagreement orally whether it should be a general release or a limited liability release, and there was nothing in writing, so the court couldn't do anything with that. And then the Ligon case, finally, where we actually cited that one also, where the plaintiff's attorney accepted. The plaintiff wanted to continue negotiations, and the court said, no, your attorney accepted. Everything is concluded. One last thing, Your Honor, and I'll end here, is that we did, when I can't find any cases on an issue, I normally go to secondary sources because and try and look up secondary sources to see if there's anything else, because there was really no cases particularly on the issue of the affidavit. And that kind of tells me also that it's nothing that there's nothing out there. You just need to answer the question of, was there any other insurance available? However, when I was looking at Jenkins and Miller, and these other ones, Davis and Schulman, Browns, I did find actually one of them on Westlaw, and you could see it up at the top, this is from Westlaw, this is from Browns, and it's written by Charles Adams and Cynthia Adams, Browns forms, and they actually had a form for 91167.1, the statement regarding insurance, and it says, number one, my name is insured, the adjuster for the company. Number two, all liability and casualty coverage that provides for this claim issues is as follows: policy number, amount, and that's just what we provided. Then three, they actually just say this is based upon the settlement offer and everything's correct in this affidavit, whereas we go into even more where we say there is no other insurance policy that applies to this accident. For those reasons, Your Honor, we would ask that the motion to enforce settlement be granted. Thank you.
Ms. Hassan?
Yes. Good afternoon, Your Honor. May it please the court, I'm here on behalf of plaintiff Angela Lewis. We're here in opposition to defendant's motion to enforce settlement. We believe we are here today on the issue of whether a settlement contract form. It's plaintiff's position that it has not. It's basic contract principle that a contract requires an offer and acceptance of the offer. Additionally, acceptance of the offer, excuse me, must be unconditional, identical, unequivocal, and without variance of any sort, citing Grange v. Woodard. And if there's any variance of any sort from the offer, the attempted acceptance
Okay,
is
so
a rejection.
Ms. Hassan, let's
Yes,
assume I know basic contract law.
Of course,
Tell
Your
me
Honor.
where this deviates from offer and acceptance, because to me it looks like the people with apparent authority were negotiating with each other and they were talking to each other. The policy limits are $25,000. You made a request for a demand for policy limits. We gave you policy limits. We don't have any other policies. Okay, send us the check. Okay, now that the check is in the mail, the plaintiff decided she was entitled to more money. So now she's fired the attorneys and wants to bring a lawsuit for. So where is the failure in the offer and acceptance rubric?
Yes, Your Honor. So just to cut it short, essentially our issue is with the language of the affidavit. And I understand, as Mr. Canella explained, that the overarching idea and purpose of what the affidavit they provided was seemingly to comply with what both the demand and the statute put forward, such as to say this is the only applicable policy and stating there, but also let me share my screen. As you can see here, Your Honor, in number 7 of this page, this is the Morgan & Morgan original demand. It states that pursuant to 91167.1, in order to settle this claim, State Farm must provide Angela Lewis a statement under oath regarding whether all liability and casualty insurance issued by State Farm that provides coverage or that may provide coverage for this claim has been disclosed to Angela Lewis. So, as Mr. Cannella also went through, the affidavit itself essentially did not answer the exact question that this demand and the statute itself was asking.
What did it leave out?
So the statute and the demand, it essentially is asking, tell us whether these have been disclosed. So the two answers that you can give essentially are, yes, they have been disclosed, or no, they have not been disclosed. So the way it's written is essentially previous disclosure. So essentially what the affidavits, in both affidavits in this case, just said is, this is the applicable policy, and they stated the policy as it was, and that we do not know of other policies.
Okay, so hold on.
So
you're
yes, ma'am.
You're saying that the entire agreement should be invalidated because they didn't say, yes, we disclosed the policies and ended there. So that if they instead of disclosing the policies and telling you which policies are available, and the fact that the policy that they discussed is all the policy that exists, instead of giving you all of that information, what they should have just said was, yeah, we disclosed it.
Not just that.
Ms. Hassan, I'm not going to invalidate a contract based on form over substance, because we're all lawyers and we all draft things differently. And as long as the drafted information complies with what is required to give notice, which is the bedrock of due process. So was she given notice of what policies were available, what those policy numbers were, who was the provider or an underwriter of those policies, and whether they would cover the claims that she was making? Was she given all of that information?
Yes, Your Honor, but we also feel that the way this affidavit was written, it kind of leaves loopholes for a State Farm to later come, and if there are resident relative policies or umbrella policies that exist, to later on plaintiff would not have a remedy. If this case was settled under this affidavit, if those policies are later discovered, as the way it's written is, that apply to the defendant.
Okay, then you would have a remedy against the attorney or for malpractice or some other remedy, but they've provided an affidavit that said, we don't know of it. Instead of just saying, yeah, we disclosed this through whatever conversations we've had or whatever information that a lawyer to a lawyer was being communicated, instead of just saying, yeah, we disclosed it, they've set out what exists, and they've said, we don't know, we're State Farm, we should know if they exist, if there's anything else. We don't know of anything else that would cover this accident and these injuries.
Yes, that's understandable, Your Honor.
Did you review, and you don't have to tell me what you review, but did you review the file from Morgan & Morgan before you decided to take this case?
Yes, so we reviewed what the client had provided to us, and I did reach out to Mr. Cannella to get additional documents, such as the email communications between him and the attorneys at Morgan & Morgan regarding the exact acceptance language. And then from what he provided and what he also showed here today, I'm not privy to the phone conversations that they had. I don't have the information from that, but from what they provided in saying, yes, there was an agreement prior to her firing us and coming over to my firm. It's our position that at that point, they had not made any kind of essentially ratification or acknowledgement that there was a settlement. So at that point, since they were no longer her counsel, we essentially weren't acknowledging that this was them essentially saying that there was a settlement.
Okay. All right. Anything else?
Yes, Your Honor. So additionally, as I stated, there was a difference between, in our position, a non-conforming statement that we think State Farm provided in response to both demands and how they stated it. We believe a conforming demand should have stated specifically disclosure language. Yes, all policies have been disclosed to Miss Angela Lewis or her counsel, or they have not been disclosed, and here are additional policies. We believe it as it stands, it just leaves open gaps for future recovery that the plaintiff would not be able to have. And additionally, as the affidavit stands, it shows that State Farm unilaterally made the determination of what policies applied and did not give any indication of disclosure or even search for other potential policies and that would allow plaintiff to investigate or ascertain whether those policies could apply. And moving forward, this would allow State Farm and even other insurance companies to unilaterally make the determination and not give any plaintiffs the remedy of doing their due diligence and seeing if those other policies would apply. I don't understand the purpose of avoiding the disclosure language, as both demands clearly state whether or not they have been disclosed, and additionally, so does the statute itself. So as a result of this, we are asking to have all evidence viewed in light most favorable to the non-movement, which is plaintiff. And even if this court finds that the demand or offer didn't comply with the statute, we believe that as the offer was presented, it did accept everything in the demand, which, let me additionally just share my screen one more time. Later in the second demand that my firm sent in, all right, in number 7, this is essentially the same term that Morgan & Morgan sent. We provided additional clarifying language that any other statement not exactly as prescribed by 9/11/67 B1G regarding whether all liability or casualty insurance by State Farm has been disclosed to the offeror is refusal to comply with the statute, which is a material term, and it'll be considered a rejection of this offer of compromise. And like stated, we believe that it was not an exact statement of what was required, which effectively we took as a rejection and counteroffer. So therefore, we believe that the evidence taken in light most favorable to the non-movement, which is plaintiff, the court should find that there was no contract. And additionally, even if the court finds that the demand or offers did not comply with the statute, the defendant cannot accept anything other than the exact offer as presented, and contract formation is not a punishment for non-compliance of the offer. So therefore, we ask the court to deny defendant's motion to enforce the settlement. Thank you, Your Honor.
You're welcome. Anything else?
No, Your Honor.
All right. The court will issue an order. Thank you.
Thank you, Your Honor.
All right, you may be excused.